All right, hi, welcome back, Attorney Steve Vondran. Today we're talking about seizure orders, not the kind that are harmful to a person, but when you have trademark violations, a seizure order, okay? So under the Lanham Act, if somebody even suspects or has some proof that somebody is going to commit infringements, trademark infringements, counterfeit, they can seek a seizure order from the court. And this is an order to allow them to seize infringing goods. And we got a good example here for you today. This is TAS Rights Management, LLC. Anybody know who that is by chance? Taylor Allison Swift, I believe it's Allison Swift, Rights Management. It's her company that registers trademarks, a lot of trademarks in her name, including her own name, Taylor Swift. Registered, pretty much you can register stage names. And she was able to register Taylor Swift. Why? Everybody knows her and her brand, and so she was able to get a registration. So if you're selling counterfeit products, fake knockoffs, copycats, people will think that maybe she's endorsing the product, and it could lead to a trademark infringement lawsuit and seizure at the concert. So let's take a look here. But Section 1116, 15 United States Code 1116 allows for seizure orders where counterfeit and trademark counterfeits are going to happen or have happened and a lawsuit is filed. So let's take a look here. One of the requirements is that this is here in the Middle District of Tennessee in Nashville. One of the requirements to get a seizure order is you need a here we have an ex parte motion and a declaration. You need some sort of declaration or affidavit from somebody setting forth what's going on. And here's a guy, Douglas Baldridge, declaring I'm over 18. And by the way, this is what a declaration looks like. It's pretty simple. Some people call it an affidavit. I am over the age of 18. I am competent to attest to this certification. I have personal knowledge. You always have to allege that in a declaration. I have personal knowledge of the facts set forth herein. If called to testify, I would testify competently hereto. That is a requirement of your declarations. I'm a partner at the law firm Venable, counsel for plaintiff, TAS Rights Management, the plaintiff. I submit this certification pursuant to Rule 65B of the Federal Rules of Civil Procedure. That deals with injunctions. And plaintiff has filed a lawsuit. This was in regard to, here's a case that was actually filed, a federal court case. And anyway, this says plaintiff has filed remedies against defendant's trademark infringement and use of counterfeit versions of Swift trademarks in violations of Section 32, 34, and 43 of the Lanham Act. Here's your code sections. Plaintiff has notified the U.S. attorney. This is one of the unique requirements to get that seizure order. You have to notify the U.S. attorney in the district where you're seeking the seizure order. So that's what they're saying here. The plaintiff has applied to the court for an order enjoining the sale of merchandise bearing counterfeits of the registered Swift trademarks, and she has a bunch of trademarks, as I mentioned, counterfeit goods, and for the seizure of counterfeit goods, all within a 20-mile vicinity of the concert venues, and I'll be showing you those in a second. So they're getting a pretty wide range, saying, we believe, here's what we believe. I assume that they find people that are repeat offenders and people maybe they're advertising online. Come see us out at the Dallas concert, DDD, come get our goods. So they need to also keep this secret. You cannot publicate this. You need to keep the defendant's basically identity secret so they don't know about it. When the judge issues an order on this, that gets recorded on the docket under seal. So that's how it goes. And so they're saying that we want within a 20-mile vicinity of all concert venues at which Taylor Swift will be performing, there's quite a few, in the United States as part of the Taylor Swift, the Eras Tour, during and within 24 hours before and after each performance. So somebody's going to be out there. If the judge grants this order, which I'm assuming probably will, then they will be able to go out and seize counterfeit goods, literally walk up to them, say, hey, we have a seizure order here from the court. Defendants are individuals and entities who have and will, in connection with the tour, manufacture, distribute, advertise, and or sell the counterfeit goods. So somehow they already know these people are probably like repeat offenders. It is a common practice of counterfeiters at live entertainment venues events to set up operations quickly and for a short time and then vanish with their goods and illegal profits before judicial relief can be sought. It is not possible to notify the unnamed defendants of the pendency of this action on plaintiff's application to this court because the identity and the whereabouts of the defendants are presently unknown. Further, plaintiff believes that if notified of the pendency of this action and the nature of the relief sought, defendants will conceal or relocate the counterfeit goods outside the jurisdiction of this court. Such behavior would make it extremely difficult, if not possible, for the court to adequately achieve the purposes of Section 1114 of the Lanham Act that deals with trademarks and prevent defendants' use of counterfeit registered SWIFT trademarks. So if counterfeit fan art, something says has her name on it or one of her trademark names or something to do with her tour, if the judge grants this, they're going to be able to go out and seize the goods, okay? If defendants are permitted to engage in their infringing activities, plaintiff will be irreparably harmed. Plaintiffs will suffer irrevocable loss of sales of plaintiff's genuine and authorized merchandise in undeterminable quantities, and plaintiff will suffer loss of reputation and goodwill through the sale by defendants of unauthorized counterfeit merchandise of inferior quality. So you could have like really cheap t-shirts. Maybe somebody gets the $2 t-shirts and puts a logo on it and you think it's Taylor Swift authorized. That's what they're trying to prevent. And so forth and so on. No other ex parte, nothing, no order other than an ex parte seizure order. That's just ex parte is where one party goes in, asks the court to grant the order. The other party's not there, would adequately achieve the purposes of this section. Plaintiff has not publicized this action or the nature of the relief sought. Remember, I said that's a requirement. And so forth and so on. So there it is. And they're saying, here's the venues. We want an order. And here actually is the letter that the law firm sent. This is regarding task rights management. And they sent this to the United States Attorney General, United States Attorney, Middle District of Tennessee in Nashville. And as I mentioned, this is a requirement. You have to send it here. So all they're saying is, dear Mr. Leventis, Henry Leventis is the U.S. Attorney there. We will be filing a civil action next week. We got a network of trademark infringers. The defendants are individuals and corporations who have or will offer counterfeit merchandise for sale. So somehow they know people will be doing it. We have determined through our investigation that these entities or individuals are or will be actively distributing counterfeit merchandise in this judicial district. As part of our request for relief, we will be seeking a seizure order from the U.S. District Court, Middle District of Tennessee, pursuant to the Lanham Act 15 U.S.C., that's United States Code, Section 1116. From March, here's the dates they're seeking for, a seizure order from March to August. So that's good, 4 or 5 months in there? March, April, May, June, July, August, 5-6 months. We intend to execute this seizure order at or near concert venues during the tour entitled Taylor Swift Airs. So they give the notice to the attorney. The Lanham Act requires us to give notice of our intent to seek an order. Please advise as soon as possible if your office has any interest in participating in the action against the above referenced defendants. So whether they participate or not, that's something to remain to be seen. And we thank you for your assistance. So that's it. Here's the concert venues. This was 2023. You can see out here State Farm Stadium in Arizona, Allegiant Stadium in Nevada, AT&T Stadium, Texas, all kind of Mercedes-Benz out in Atlanta, Georgia. You got the Lincoln Financial Field in Philadelphia, Pennsylvania, Soldier Field, Chicago, Illinois, so forth and so on. So you see you got the Arrowhead Stadium, Kansas City. There you go. So that's it. That's a seizure order in a nutshell. This is general legal information only, not legal advice. If you need help with trademark infringement, seizure orders, responding. What can happen, by the way, is if the order is against you, you will get a copy of the seizure order, and you usually have 30 days to respond to let the judge know how you're complying with the order. And there would be a chance to have the order called off if you're actually in compliance, or maybe you actually didn't sell anything, and so there's nothing to seize. Or maybe you have a proper license. So anyway, that's a quick look at trademark infringement, counterfeits, counterfeit goods, fan art, fan promotional items, and seizure orders. What could happen if you're doing counterfeits? Now, again, that's only part of it. The other part is you can be sued in a federal court for trademark infringement. so forth and so on, and to disgorge your ill-gotten gains. Disgorge your ill-gotten gains. All right, everybody, Attorney Steve, if you need some help, you know where to find me on the web at attorneysteve.com. That's attorneysteve.com, the first name in legal services. I got to run. Have a great evening. Feel free to share this video on your social media networks. Bye now.